Gronits and Gronits,
Sure.
and this is on for review.
No.
And Miss Hartman, any updates?
I believe this is just on the respondent's motion for attorney fees.
Mandy Garnett, Gronits present. Can you hear me?
Yes, ma'am, we can hear you. Thank you.
Oh, good. Okay, thank you.
My understanding was that when we were here on the 10th of October, she was withdrawing that request. Is that in this cause number? Is that correct, Ms. Gronitz?
Yes, I'm
Okay, unfortunately, you just cut out, Ms. Gronitz. I don't know. Could you state that again?
motion to strike lawyer fees. Strike that. My situation has dramatically changed.
Okay. So when we were here on
discussing the move today.
What was that again? I'm sorry.
They put in a motion to move with the children. Is that getting discussed today?
No, my understanding is that has been noted on for, I don't know that a date has been set for that yet. Do you see, Miss Hartman, a date set for that notice?
I believe all we've done is file. We haven't set a date yet.
Okay. So Ms. Gronitz, no, that's not being addressed today. That is yet to be noted up for hearing by the moving party. And that they would have to serve that date upon you.
Comment. My life is in imminent danger, and I approve the move because I can't see my children until I'm not in danger anymore.
Well, I'm sorry to hear that. I don't, I hope you know who to contact if you are in imminent danger, that there are resources available to you, and 911 is always an option if there's imminent danger. So please use that if it's necessary. If you do find yourself in a situation where you can contact Ms. Rush's office and you are in agreement with the move, you can contact them to let them know that. At this point, it's not before the court. So I'm not exactly sure. It just says a review hearing today, and I don't know that we have anything to review. So please, Ms. Gronitz, take care of yourself. And then I guess Ms. Hartman, I'm assuming you or Ms. Rush will get that noted up in the near future if it's not agreed upon by the parties.
Yes, we will.
All right. Thank you very much.
Thank you.
Thank you, Your Honor.
Thank you, Ms. Gronitz. Heintzman and DeGruber Evans. And I think this is one of the ones where I do have an order. There was some objections to that order. And this is I just want to clarify because there were two proposed orders on the September 12th hearing. And one of them, they're different. So, and I'm assuming, well, I didn't want to assume, but I didn't know if the updated version addressed any of Mr. Swenson's concerns or if there were just, okay.
So I think the order that I'm prepared to work off of today has my signature on the 21st of September.
That's the one I have.
Perfect.
And I'm assuming, so your objections were to the same one, Mr. Swenson?
Believe some of them.
I think the prior order, Stephen, was before we had added the little red barn language in there.
Okay.
So I think that's the difference. Mm-hmm.
Okay, so objection number, the first objection is to paragraph number 1, and the language about every week adding, every week being an overnight and then adding a 5th week of visits. Here's where I had a little bit of confusion because I'm just stating this for the record, so hopefully we're all on the same page. When we started the court date on the 12th, Mr. Swenson wasn't present, and so I didn't realize that until halfway through reading the minutes. So certain things were addressed that I thought were addressed in front of Mr. Swenson that actually were not. So and I'm just pointing that out because it kind of tricked me up. Initially, you probably are more, well, it's your guys' case, so I'm sure you're on top of that, but I just was a little confused initially. So there was a discussion about moving to overnights. There was not, from my recollection and from reading the minutes, necessarily a specific discussion of every visitation being an overnight while Mr. Swenson was present. There was before he was present. And then I said, hold on, he's not present. So it's kind of a weird position there, weird posture. So I guess I'll start with you, Mr. Swenson, since it's your objection to the proposed order.
Thank you, Your Honor. For the record, Stephen Swenson for Gabrielle Evans. For what I was present for and what I think the previous conversations were in the court, because this was a review hearing, was continuing the schedule as the first 2 Saturdays and third and fourth Wednesdays. And for the part I was present for, there was no discussion of whether there was a 5th week or not. And I don't think there was anything mentioned in the pleadings on that or in your order. So we'd ask that that not be included. I think it also says in the notes, sorry, it also says in the notes that this was for an agreed order. We haven't agreed to a 5th week. So, and while in court, Chad Zandy, I think, was covering for Miss Bliss. I had asked whether the schedule still worked the first 2 Saturdays and the third and fourth Wednesdays, and Mr. Zandy had said they had. So there was no discussion of a 5th week. So we'd ask that that not be included in the order. And then based on the minutes, it looks like Thanksgiving and Christmas were mentioned. If you don't mind me moving on to that, the second objection as well, Your Honor.
Just to clarify, you can do that. Let me just clarify this. So there's no opposition to those Wednesdays and Saturdays becoming overnights, but there
Correct.
is opposition to the 5th weekend happening at all.
Yeah, and
Okay.
and it sounds like the proposed order is just a 5th day to be decided between the parties. And with the parties, there's a protection order in place. There's been allegations of abuse in the past, a finding of DV. So it would be difficult every month. There's a 5th day to arrange another overnight.
Okay. All right. And then you can move on to the holidays. Go ahead.
And the holidays, it looks like were mentioned for the first time at the review hearing on September 12th, when I wasn't present, but then also when I was. And my client opposes those at this time. And so there was no notice of this in the motion. So it hasn't even been briefed by the parties. I see Mr. Heinzman submitted a declaration, but I don't think it's proper without a notice of motion. So we ask that that provision be stricken.
And 3 and 4 are okay.
Correct.
Ms. Bliss, thank you.
And Judge, thank you. Mr. Zandy was filling in for me on the September 12th hearing, so I do only have his notes, which are largely difficult to read, and then the clerk's minutes to go off of. I know it was our intention to request the overnight visitation. Upon my review of his notes and the clerk's minutes, it looks like there was some discussion of visits every week. This was a discussion that my client and I have had at length. The fact that the current schedule of the Wednesday, Thursday, and Saturday, Sunday overnights were largely proposed by Ms. Evans. The parties agreed to that. It was ordered long ago. But the issue of the 5th week continuously comes up. My client was under the impression that Your Honor had previously ordered visits are to occur every week. That has been contained in several orders at this point, but then it's gone further into saying first, second, Thursday, Friday, Saturday, Sunday, third and fourth week, or something to that effect. I don't see that there's a reason to limit his 5th week. We're simply asking for that. Going to Mr. Swenson's comment on notice and discussing the holidays, frankly, everything was on the table with this motion. The motion was to modify the visitation, expand visitation. We've consistently had these reviews every 6-8 weeks to continuously increase that visitation. My understanding of the clerk's minutes and Mr. Zandy's notes as of September 12th, the holiday schedule was addressed in court. Your Honor essentially wanted Mr. Swenson to have the ability to speak with his client It was my understanding Your Honor wanted a declaration or something to substantiate our request for the holiday visitation. And frankly, it's appropriate. My client provides in his declaration he hasn't had any holiday visitation with this child in the last 2 years. Requesting a couple hours on Christmas and a Thanksgiving visit, I don't think is unreasonable. I don't think there's any reason to deny it other than to deny it by Ms. Evans, who has consistently caused some problems. But beside the point, my client is asking for holiday visitation. I do think it's appropriate. The initial motion to expand visitation was vague and left completely open, and we've continuously come before the court for reviews for Your Honor to expand visitation. So I do believe it's properly before the court, and I do believe that Your Honor has the authority and should order it.
Any response, Mr. Swenson?
Just that the notice requirements are supposed to be specific, so that it can't be open to everything, like asking for an expansion of parenting time and then just letting that open the door to everything isn't specific enough to provide due process or proper notice. So it wasn't specifically prayed for or briefed, so that's to be denied.
So the order I have in front of me, Ms. Bliss, indicates father's request for holiday visitation is hereby reserved pending further hearing on October 3rd. And October.
And that was when this was initially set for, and then Judge Scudder had heard that docket and sent it over to today so that it could be in front of Your Honor to address that issue. Because it was, again, my understanding that you wanted some sort of declaration on that request.
And my understanding was Your Honor asked for an agreed order if we could come to an agreement, which clearly we haven't.
Okay, I am gonna, here's one of, as for paragraph 1, I'm gonna line out if there is a 5th week in the month, that entire sentence. I think given the history, there probably needs to be a little bit more defined visitation. If parties can agree to something, I'm happy to consider that moving forward. As to the holidays, I understand the concern with noting it on the historical posture of this case going back several hearings is every hearing this is what we're trying to do, this is what we want to expand, here's what's going good, here's what's not going well. There was a declaration regarding holidays September 21st, so well over a month ago, that was filed by Mr. Heinzman regarding the want for a little bit of time on Thanksgiving and Christmas. I'm gonna grant partially the request. So I'm gonna give a father the visitation on December 25th from 9, but I'm gonna make it 9 to 3.
9 a.m. to 3 p.m.
Yes.
And then in paragraph 1, are you striking the words every week?
Let me get back to that in 1 second, because I read that several different ways. Because he is having contact every week. It's just not every Wednesday and every Saturday. So if we need to address that for clarity, we can definitely do that.
Yeah, sometimes because of the first and second Saturday and third and fourth Wednesday, it'll be over a week before he'll see the child. Sometimes they'll be close together, sometimes they'll be far apart.
So if we, Ms. Bliss, if we just eliminate the once per week, that first part of that sentence, petitioner's visitation shall continue and expand to unsupervised overnights, 24-hour period, occurring on the first 2 Saturdays and third and fourth Wednesdays per month. Does that?
I think that's fine.
Okay. Does that work for you, Mr. Swenson, to clarify that?
Thank you.
All right. All right. And may I indicate approved via Zoom on your signature line, Mr. Swenson?
Yes, Your Honor. Thank you.
And Your Honor, just so I can notify my client, you approved of the Christmas with the change to 3 o'clock and you denied the request for Thanksgiving.
Yes.
Okay. Very good. Thank you.
All right. I will get this to the clerk, and I don't know how that amazingly we just got done. So thank you very much.
He pays the rent. He do his part. He does his part as a man. I'm not saying that he does not. He's getting upset. I'm not saying that he does not. But I am scared. I am terrified right now. I am.
Okay,
Police
uh,
report today.